Hey guys, how you doing? This is Matt Zugsberger here, coming to you from Balboa Park here in lovely San Diego. Getting ready to leave out to go surrender myself to Arizona for a warrant there for failure to appear, because apparently that's not a willing reason or an excusable reason to miss court if you're in jail. But we'll touch a little bit up on one story that doesn't get a lot of attention. It's my Louisiana story. In Louisiana on June 18, 2008, state police officers kicked in my door, my ex-girlfriend's door, while I was house sitting. It was me and my two small dogs there and a friend of mine, Mike Mahoney. And they kicked in the door because I had received a package from FedEx, which had been intercepted with two pounds in it. At that point, the police, of course, did their standard searching and had everybody in cuffs. It was a no-knock warrant. They busted through the door with ramming bars and small-grade explosives. Blew the door right off the hinge. They immediately arrested me and had me in custody, and as they were going through and getting all the evidence together, I asked the officer, I said, "What law have I violated, sir?" The officer informed me I had violated state law RS 4966, which is part of their Dangerous Uniform Controlled Substances Act of 1974. I quickly at that point pointed out to the officer that in RS 4966 Title C clearly stated that no person shall knowingly or intentionally possess a dangerous controlled substance classified in Schedule 1 unless such substance was obtained directly or pursuant to a valid prescription or order from a practitioner, or as provided in RS 40978 while acting in the course of the physician's professional practice. All others who violated this subsection with respect to. The officer at that point says, "Well, you don't have a valid prescription." This is what they call a recommendation. I said, under the legal definition of that document, it is considered a clinical order for a drug or a therapeutic aid, which falls well within the guidelines of your state-limited legal definitions for a prescription. A written request for a drug or a therapeutic aid to correct a mental, physical, or psychological ailment. At that point, they said, "Well, this is from California and we don't have to honor that." That's when I advised the police officers of Cox versus Louisiana, Baker versus General Motors, and the Full Faith and Credit Act of the United States Constitution, Bill of Rights, Article 4. They didn't see it that way. They took me to jail. Luckily for me, there's some compassionate people everywhere you go. The intake officer at the jail realized immediately what the parameters of this case were entailed by, and she called the judge and said, "Your Honor, as a cancer survivor, as you know, I do support medical marijuana if it's legal, and this man has a valid prescription. I've verified it, Your Honor." At that point, the judge gave me a $5,000 bond. Upon further discussion with the Troop C of the Louisiana State Police, I brought to effect one of the questions they had for me, a voluntarily interview. Did you pay such said tax on the plant, which falls under their law of RS 47-2601. It specifically says that a dealer tax will be imposed of $3.50 per gram of marijuana. I quickly pointed out to them, though, under their state law RS 47-2610, that no person rightfully in possession of marijuana is required to pay such said tax. Their next question was about the paraphernalia, the pipes, and the rolling papers. I quickly pointed out it shall be an affirmable defense under RS 40-1024 that the drug-related object or advertisement was designed or specifically designed for use or for bona fide medical, agricultural, or psychological purposes. It shall be an affirmable defense that the drug-related object in possession of the individual was used for medical marijuana shall be used in his defense. I also informed them of a state case law, Webb versus State, which showed that if a person claimed medical necessity, regardless of sales issues, if he could prove that it was a non-profit sales issue, then he was only to be charged with simple possession. The DA in Louisiana has a right to charge someone with simple possession up to 60 pounds. Since then, there's been several motions in the court. One to quash the case. That motion was denied, but the judge did say, this is not a reason to quash the case, but this is one of the finest affirmative defenses I've ever seen to any charges brought against a citizen of the state of Louisiana. The prosecutor, you're going to have a very difficult time proving in court that this is not a solid affirmative defense, and I'm hereby ordering that Mr. Zugsberger be allowed to use this as an affirmative defense. The case has been lingering now about 3 years. It was set to go forward earlier this month, but with the BP oil spill and other mitigating factors, the trial was postponed once again. I've reached out to several Norml attorneys down there. Things didn't work out real well between me and them. Not that it's a bad thing, they had their own agendas they had going on, or too many case law, or too far. But, I'm still continuing this fight. I do believe that the law is what it says it is. And regardless, even if they said the law was against marijuana, and there was no law pertaining to marijuana in their state for a positive aspect for a patient, I still retain my Article 4 rights. The citizens of each state shall be entitled to all privileges and immunities in the many states. Any judicial, legislative, or civil action pertaining to the citizens of one state shall apply in the many states. To give someone a state-issued card with a state seal on it and have another state not honor that is paramount to tearing at the fabric of the United States. If we are going to be a federalist nation, as the Jeffersonians wanted us to be with a central government power, the Interstate Commerce Clause must be honored at all costs. If there's a state seal affixed to an item and it was properly put on that item, then it should be honored in the many states. Other cases I've dealt with, Washington, for example, I won that case. Even though I did take a plea deal, people can call it what they want, but I won. I walked away from that case with a simple possession charge for having more medication than legally prescribed. But yet, I also turned around and I became the first person in the United States to win an interstate medical marijuana trial along with my girlfriend. We both were given back our allotted 5 pounds of marijuana in 1.5 pound increments every 7 days. It just goes to show that it's pretty ironic that other states respect medical marijuana laws in California and my rights as a constitutional being more than they do even in California. Another case that I had was a big case in Sacramento where I was arrested getting on the airplane with 3 pounds. Still well within my prescriptive rights, and yet they charged me with possession with intent to distribute and transportation. During trial, I was found innocent of possession with intent to distribute, but guilty of transportation with intent to distribute. A giant conflict of interest there. Especially when the jury instructions were said that if you don't find Mr. Zugsberger guilty on count 1, you must not find him guilty on count 2. If he's guilty on count 1, then you can find him guilty on count 2, or you should find him guilty on count 2. But that case is in the appellate court right now, and I'm sure that they'll find many, many problems, which they already have, with the jury instructions, and it will be remanded, and I probably will win or have it dismissed in the next case. The next case to address is my Arizona case. I don't want to talk too much about that. It's still very much new in the fires, but I can assure you of this. It was very much an illegal search and seizure. The co-defendant is going to be used as a witness against me. Unfortunately for him, it's going to kind of backfire on him when I use my affirmative defense that shows that the 10 pounds that I was arrested with were the 10 pounds given to me by police in another state. So once again, another 4th and 5th Amendment case. Arizona has a lot of problems right now dealing with a lot of issues. They're not bad people there. It's still a good state. Within the borders of the United States, this is still a great country. But we need to reaffirm our rights. We need to stop waiting for someone else to make the leeway for all of us on all issues. It's not just medical cannabis. It needs to be for all issues. Taxation without direct representation, proper health care, educational services, public safety,
That's it.
These are all